Memorandum Circular Number 2016-002. Revised Rules of Procedure before the Administrative Disciplinary Authorities and the Internal Affairs Service of the Philippine National Police. Pursuant to Republic Act No. 6975, otherwise known as the Department of the Interior and Local Government Act of 1990, as amended by Republic Act No. 8551, otherwise known as the Philippine National Police Reform and Reorganization Act of 1998, the provisions of NAPOLCOM Memorandum Circular No. 2016-002, NMC 2016-002, are hereby prescribed and promulgated. Rule 1. Preliminary Provisions. Section 1. Title. These rules shall be known and cited as the Revised Rules of Procedure before the Administrative Disciplinary Authorities and the Internal Affairs Service of the Philippine National Police. Section 2. Scope and Application. These rules shall apply to all administrative cases filed against uniformed members of the Philippine National Police, PNP, before the different administrative disciplinary authorities and the Internal Affairs Service, IAS. Section 3. Construction. These rules shall be liberally construed to attain just and expeditious disposition of administrative complaints and cases against PNP members, ensure public accountability and utmost discipline in the police service. Section 4. Nature of Proceedings. The investigation and hearing before the administrative disciplinary authorities and the IAS shall be summary in nature and shall not strictly adhere to the technical rules of procedure and evidence applicable in judicial proceedings. The provisions of the Civil Service Law, rules and regulations as well as the revised rules of court shall be supplementary applicable. Part 1. Administrative disciplinary authorities, Internal Affairs Service, appellate bodies, and their respective jurisdiction. Rule 2. General Provisions. Section 1. Definition of terms. As used in these rules, the following terms shall be understood to mean as follows. Answer: a responsive pleading containing the respondent's negative and affirmative defenses. Appellate bodies shall refer to the Regional Appellate Board, RAB, and National Appellate Board, NAB, of the Commission, the Secretary of the Interior and Local Government, SLLG, and the Civil Service Commission, CSC. Breach of internal discipline: any offense committed by a member of the PNP involving minor offense affecting the order and discipline within the police organization. Minor offense refers to an act or omission not involving moral turpitude, but affecting the internal discipline of the PNP, and shall include, but not limited to, simple misconduct, negligence, insubordination, frequent absences and tardiness, habitual drunkenness, and gambling prohibited by law. Citizen's complaint: a complaint initiated by a natural or juridical person or its duly authorized representative or guardian on account of an injury, damage, or disturbance sustained as a result of an irregular or illegal act or omission of a PNP member. Commission shall refer to the National Police Commission. Complaint: a written and sworn statement regarding a wrong, grievance, or injury sustained by a person. Complainant: one who initiates a complaint against a uniformed member of the PNP, either as complaining witness or as a concerned government agency or office. Decision: the written disposition of the case by any disciplinary authority, IAS, or appellate body stating clearly the facts and the law upon which it is based. Disciplinary authorities shall refer to the city or municipal mayors, chiefs of police or equivalent supervisors, provincial directors or equivalent supervisors, regional directors or equivalent supervisors, People's Law Enforcement Board, PLEB, Chief of the PNP, National Police Commission, NAPOLCOM. Equivalent supervisors: PNP officers occupying positions/designations equivalent to that of Chief of Police, Provincial Director, and Regional Director who are vested with disciplinary authority over personnel of their respective offices, charged with minor offenses involving breach of internal discipline as provided under Section 41(b) of RA 6975, as amended. For purposes of these rules, the following are considered equivalent supervisors. Chief of Police. Chief, Provincial Public Safety Company. Chief, District Public Safety Battalion. Chief, Police Station of Manila Police. District and Quezon City Police District. Provincial Director. Director, City Police Office of Highly urbanized or chartered cities. Chief, Regional Public Safety Battalion. Chief, Regional Administrative Support Unit. Chief, Regional Operational Support Unit. Regional Director. Director, Police District Office, National. Capital Region Police Office. Director, National Administrative Support. Unit. Director, National Operational Support. Unit. In case the head of any of the above enumerated offices/units of the PNP is only an officer in charge, she may conduct investigation and submit his recommendation to the next higher disciplinary authority. Finality of decision. There is finality of decision when upon the lapse of 10 days from receipt or notice of such decision, no motion for reconsideration or appeal has been filed in accordance with these rules. Forfeiture of salary, a penalty imposed upon the respondent who is found culpable of the offense charged, which consists of taking his salary for a certain period but in no case shall exceed 1 month. The respondent who is penalized with forfeiture of salary is required to report for duty. Formal charge, a complaint initiated before any of the disciplinary authorities or IAS after finding the existence of probable cause. Forum shopping, the filing of several complaints arising from one and the same cause of action involving the same parties asking for the same relief with the different administrative disciplinary authorities, the Internal Affairs Service and the Office of the Ombudsman. Jurisdiction, the authority vested by law to hear and decide a case. Moral turpitude includes everything which is done contrary to justice, honesty, modesty, or good morals. It is an act of baseness, vileness or depravity in the private and social duties which a man owes to his fellow men or to society in general, contrary to the accepted and customary rule of right and duty between man and woman. Newly discovered evidence, that evidence which could not have been discovered and produced during the hearing of the case despite due diligence, and if presented, would probably alter the decision. Pending case refers to a case when the respondent has been formally charged before any disciplinary authority or IAS or the Office of the Ombudsman, or an appeal is pending with any of the appellate bodies. Pre-charge investigation is the preliminary examination and evaluation of the complaint for the purpose of determining the existence or non-existence of probable cause. Probable cause is the existence of such facts and circumstances as would excite the belief, in a reasonable mind, acting on the facts within the knowledge of the investigator, that the respondent is probably guilty of a specific administrative offense or offenses. Recidivist, a person who has been previously penalized for a grave administrative offense and is again charged of another or the same grave administrative offense. Reglementary period, the period required by law or these rules to perform a specific act. In the computation of a period of time, the first day shall be excluded and the last day shall be included unless it falls on a Saturday, Sunday, or a legal holiday, in which case the last day shall fall on the next working day. Repeatedly charged, when a police officer is formally charged administratively of a less grave or light offense for at least three times and was found culpable in any one of them. Restrictive custody is a disciplinary measure that may be imposed by the Chief, PNP, the PNP Regional Director or Equivalent Supervisor, the PNP Provincial Director or Equivalent Supervisor during the pendency of a grave administrative or criminal charge filed against a subordinate police officer/S, which may consist of confinement within the camp with proper accounting and monitoring of their activities, provided that when situation warrants and they are required to go outside of the camp, they should be properly escorted on a one-on-one basis with proper recording of activities, the place of destination, time of departure, time of arrival and the names of the escorts, provided further, that a police personnel under restrictive custody is required to turn over his issued firearm to the responsible supply officer within the same period of custody. Restriction to specified limits, a penalty which prohibits the respondent to be at a specified area. Serious charge refers to a complaint involving an offense where the maximum imposable penalty is dismissal from the service. Subpoena ad testificandum, a process directed to a person requiring him to appear and testify in an investigation or hearing. Subpoena duces tecum, a process directing a person to appear and bring with him books, documents, or things under his control in an investigation or hearing. Substantial evidence, such relevant evidence as a reasonable mind might accept as adequate to support a conclusion. Summary hearing officer, an officer designated by the disciplinary authority or IAS to conduct the summary proceeding and to submit a report of investigation. Summary proceeding, an expeditious administrative proceeding conducted consistent with due process to determine the culpability or innocence of the respondent, and summons is a written notice informing the respondent that he is charged with an offense and directing him co-file his answer. Section 2. Principle of exclusivity. When a complaint or charge is filed against a PNP member as described in Section 1 Rule 15 hereof, it shall be heard and decided exclusively by the disciplinary authority or IAS which first acquired original jurisdiction over the case, subject to the following provisions. The Office of the Ombudsman, 0 megabytes, shall have primary jurisdiction over administrative cases filed either before the NAPOLCOM or PNP against officers and members of the PNP for acts or omissions arising from the following criminal offenses filed or pending before the 0 megabytes. Violation of the provisions of Republic Act No. 1379, an act declaring forfeiture in favor of the state any property found to have been unlawfully acquired by any public officer or employee and providing the proceedings thereof. Violation of Republic Act No. 3019, Anti-Graft and Corrupt Practices Act. Violation of Sections 7, 8, and 9 of Republic Act No. 6713, Code of Conduct and Ethical Standards for Public Officials and Employees. Plunder under Republic Act No. 7080, an act defining and penalizing the crime of plunder. Violation of Republic Act No. 9184, Government Procurement Reform Act. Violation of Republic Act No. 9485, Anti-Red Tape Act OL 2007. Bribery under Section 2, Chapter 2, and malversation under Chapter 4 of Title 7, Book 2 of the Revised Penal Code, as amended, and violation of other graft laws. The NAPOLCOM shall have primary jurisdiction over grave administrative cases defined and penalized under these rules. The PNP shall have primary jurisdiction over administrative cases against officers and members of the PNP for acts and omissions constituting breach of internal discipline or minor offenses defined under RA 6975 as amended by RA No. 8551, violation of the Civil Service Law and its implementing rules and regulations or PNP policies such as, but not limited to those relating to efficiency in the performance of official duties and responsibilities. Subject to the preceding paragraph and concurrence of jurisdiction, the IAS shall take cognizance and investigate cases enumerated in Section 2, Rule 6. Complaints for offenses which carry a higher or lower imposable penalty shall be referred to the appropriate disciplinary authority or IAS, provided that any disciplinary authority or the IAS who shall take cognizance of any complaint beyond its jurisdiction and renders a decision thereon, the same shall be void and shall not be a bar to the filing of a similar complaint against the PNP member before the proper disciplinary authority or loss, provided further that any disciplinary authority, IAS officer, investigator, or summary hearing officer who violates this provision shall be proceeded against administratively for serious irregularity in the performance of duty. Section 3. Prohibition against forum shopping multiple filing of complaints. To avoid multiplicity of cases for the same cause of action, the complainant shall certify under oath in his pleading, or in a sworn certification annexed thereto and simultaneously filed therewith, to the truth of the following facts and undertaking. That the complainant has not filed or commenced any complaint involving the same cause of action in any other disciplinary authority, IAS or Office of the Ombudsman. That to the best of the complainant's knowledge, no such complaint is pending before any other disciplinary authority, IAS or Office of the Ombudsman. That if there is any such complaint which is either pending or may have been terminated, the complainant must state the status thereof, and that if the complainant should thereafter learn that a similar action or proceeding has been filed or is pending before any other police disciplinary authority, IAS or Office of the Ombudsman, the complainant must report such fact within 5 days from knowledge. Section 4. Effect of forum shopping. Violation of the prohibition against forum shopping shall be a ground for the dismissal of the case mo proprio or upon motion of the respondent. Section 5. Application of the principle of residential judicata/bar by prior judgment. For a prior judgment in an administrative case to constitute a bar to a subsequent administrative action, the following requisites must concur. It must be a final judgment or order. The disciplinary authority rendering the same N1 UST have jurisdiction over the subject matter and over the parties. It must be a judgment on the merits, and there must be between the two cases, identity of parties, subject matter, and cause/s of action. Section 6. When respondent is a presidential appointee, after the formal charge is filed, a respondent who is a presidential appointee can only be subjected to summary proceeding after a clearance for such purpose is obtained from the office of the president. The report of investigation together with the complete original records of the case shall be submitted to the office of the president through the commission. Original jurisdiction. Rule 3. Citizens' complaint. Section 1. Citizens' complaints. Any complaint by a natural or juridical person against any member of the PNP shall be brought before the following: Chief of Police, where the offense is punishable by withholding of privileges, restriction to specified limits, suspension or forfeiture of salary, or any combination thereof, for a period not exceeding 15 days. City/municipal mayor, where the offense is punishable by withholding of privileges, restriction to specified limits, suspension or forfeiture of salary, or any combination thereof, for a period of not less than 16 days but not exceeding 30 days, and People's Law Enforcement Board, where the offense is punishable by withholding of privileges, restriction to specified limit 5, suspension or forfeiture of salary, or any combination thereof, for a period exceeding 30 days, demotion or by dismissal from the service. Rule 4. Breach of internal discipline. Section 1. Where shall be filed a complaint for breach of internal discipline shall be brought before the following disciplinary authorities: Chiefs of police or equivalent supervisors, where the imposable penalty is admonition, reprimand, restriction to specified limits, withholding of privileges, forfeiture of salary or suspension, or any combination of the foregoing, provided that in all cases, the total period shall not exceed 15 days. Provincial directors or equivalent supervisors, where the imposable penalty is admonition or reprimand, restrictive custody, withholding of privileges, forfeiture of salary or suspension, or any combination of the foregoing, provided that in all cases, the total period shall not exceed 30 days. Regional directors or equivalent supervisors, where the imposable penalty is dismissal from the service, admonition or reprimand, restrictive custody, withholding of privileges, suspension or forfeiture of salary, demotion, or any combination of the foregoing, provided that in all cases, the total period shall not exceed 60 days, and Chief of the PNP, where the imposable penalty is dismissal from the service, demotion, suspension or forfeiture of salary, or any combination thereof for a period not exceeding 180 days. The Chief of the PNP has the authority to place police personnel under restrictive custody during the pendency of a grave administrative or criminal case against him. Rule 5. Summary dismissal powers of the Napalcom, Chief, PNP and the PNP Regional Directors. Section 1. Summary dismissal case. Summary dismissal case is one where the maximum penalty imposable is dismissal from the service and the offense falls under any of the following cases: when the charge is serious and evidence of guilt is strong; when the respondent is a recidivist or has been repeatedly charged and there are reasonable grounds to believe that he is guilty of the charge; when the respondent is guilty of a serious offense involving conduct unbecoming of a police officer, and when any member or officer has been absent without official leave for a continuous period of 30 calendar days or more, provided that where dropping from the rolls is resorted to as a mode of separation from the service, the police officer can no longer be charged for serious neglect of duty arising from absence without leave, AWOL, and vice versa. Section 2. Where filed. The complaint may be filed before the following disciplinary authorities: PNP Regional Directors, Chief of the PNP, the National Police Commission. Rule 6. Internal Affairs Service. Section 1. Authority to conduct motu proprio investigation. The IAS shall conduct motu proprio investigation on the following cases: incidents where police personnel discharge a firearm; incidents where death, serious physical injury, or any violation of human rights occurred in the conduct of police operation; incidents where evidence was compromised, tampered with, obliterated, or lost while in the custody of police personnel; incidents where a suspect in the custody of the police was seriously injured, and incidents where the established rules of engagement have been violated. Section 2. Inclusion of supervisor and superiors in IAS investigations. The immediate superior or supervisor of the personnel or units being investigated under Section 1 hereof shall be automatically included in the investigation of the IAS to exclusively determine lapses in administration or supervision. Section 3. Disciplinary recommendations of the IAS. Any uniformed member of the PNP found culpable under Section 1 hereof and any immediate superior or supervisor found negligent under the immediately preceding section shall be recommended automatically for dismissal or demotion, as the case may be. B. Recommendations by the IAS for the imposition of disciplinary measures against uniformed member of the PNP, once final, cannot be revised, set aside, or unduly delayed by any disciplining authority without just cause. Section 4. Appeals from IAS resolution dismissing an administrative complaint. Resolutions of the provincial IAS dismissing an administrative complaint shall be forwarded to the regional IAS for review, while decisions of the regional IAS dismissing the administrative case may be appealed to the Inspector General. Decisions of the Inspector General affirming the resolutions of regional IAS dismissing an administrative complaint shall be appealed to the National Appellate Board.